Hello and good morning and welcome to today's Knowledge Bank. This session will be hosted by Justin Bates, Barrister from Landmark Chambers. If you have any questions throughout today's session, then please submit them via the Q&A button at the bottom of your screen, and Justin will try to get through as many as possible at the end. Today's session is being recorded and the recording will be available to watch back later today. I will be sending you in a moment some notes for today's presentation from Justin, which is going to speak to you through this morning. So without further ado, I will now pass you over to Justin. Good morning, Justin.
Morning. Hello. Right, let me just have a look at who we've got here then, attendee-wise, as people start to join themselves in. Uncharacteristically for me, I actually prepared for this well in advance of normally doing it. And I did actually write these notes that are now being sent to you, even last week, in fact. And because people are quite used to me producing my notes at the very last minute, I don't think News on the Block really realised I wanted you to have them beforehand. But that's okay. So you've got emails coming out to you with a pack of notes. What I'm going to do for a minute is just share my screen, though, show you what we've got there. You'll have a pack of notes like this coming through. You will, of course, immediately notice that there is a typo on the very first page because it is not the 21st of April 2021. It's right on the last page where I got the date right as to when I wrote when I sent these notes. But the first bit is wrong, so sorry about that. The notes in this part, or rather the notes that I want to talk about today, they're slightly frustrating because they don't really lend themselves to a consistent theme or like nice digestible chunks of area to look at. I've covered cases that I think are interesting or important in the last 15, 16 months or so. And it seems to me that they broadly break into three kind of categories. The first is we've had a series of cases about what you might call leaseholder rights. So some of them are right to manage, some of them are about how company law and leaseholder law interacts. Some of them are about the rights of leaseholders under leases, etc. I want to talk about a few of the big cases on the broad topic of leaseholder rights. The second area is forfeiture, because we've had some quite interesting cases about forfeiture that I do think are worth flagging up. So when we jump in the notes, we get down to about page 6 of the notes. We've got some forfeiture cases. And then the last bit, and probably the biggest bit, is service charges. What are we going through down here? If I jumped around too much, there we are. Yeah. So we've got some big Court of Appeal cases on service charges and how service charges work. There's not really, I wish there was a bit more of a coherent narrative to all of these, but there isn't, I'm afraid. That's the best I could do for sort of headings, and I'll try and talk about cases within that broad theme to start with. I want to talk then with a case on leaseholder rights called Holdsworth Village Management Company in Barton, because this is quite a useful one and I think quite an important one to go to when you're dealing with leaseholders who've got two hats on. You will all know better than me, I'm sure, that I would probably go so far as to say the majority of modern developments have a significant role in leaseholder management, whether by enfranchisement vehicle, so where some of the leaseholders own the freehold company, or through tripartite leases where it was set up with a management company involved, or increasingly through right to manage companies. And it's not necessarily that easy to draw a distinction between the rights of the leaseholder as a leaseholder and the rights of the shareholder of the company, or the member of the company for an RTM company, of course. And Holdsworth Village Management is an example of where it can be difficult to draw that distinction. So it's a Companies Act case, and as you might know, the Companies Act says that companies have to keep a register of their members, including the names and addresses of their members, and that members of companies are entitled to see that register for the purpose of communicating with fellow members about company business. If a member asks to see the register, the company must comply with that request unless they apply to the High Court and they get the High Court's permission not to do so. So if the member wrote to the company saying, I'd like to see the members register, please, because what I intend to do is conduct a harassment campaign against my fellow members, that would obviously be a reason for not complying. Holdsworth Village Management of Barton is a lessee-owned management company, and the only purpose of the company is to manage the building. The company doesn't actually do any management itself. Of course, it appoints managing agents to do it. Mr. Barton is a member of the company, and in his capacity as a member, he writes to the company saying, I'd like the name and address of all my other articles, please, because I want to persuade the rest of the members to remove the managing agents. And the company says, we're not doing that. We're not giving you that information, because the managing agents don't manage the company's business. They manage the company's functions as a landlord under the leases. And it's nothing to do with you as a member, how the company discharges its functions under the leases. You're only entitled as a member to know about how the company deals with itself as a company. And that case ended up in the Court of Appeal because there was a High Court case involving a different landlord that had agreed with that divide. But in this case, the High Court disagreed with that divide. So you've got two different High Court judges coming to two different views. So the Court of Appeal had to have a go at deciding whether it was right. And the Court of Appeal say, no, the company are wrong. They say, look, there is obviously a conceptual distinction between a shareholder in a company and a leaseholder, because they are not the same thing. But that doesn't mean that the divide is very easy to draw in practice. In the case of a leaseholder-owned company, you can't really draw a divide, they say, between the management of the company and the discharge of the company's functions under the leases, because the only purpose of the company is to discharge the functions under the leases. So a request to inspect the register, to contact the members to remove the managing agents, is a legitimate thing for a member to do, even though the managing agents don't relate to the company, but relate to the company's asset. It's because there's no difference in practice between the company as a company and the company as a party to the lease in these proceedings. Now, over the last 2-3 years or so, I've seen a lot of these requests being made for inspection of company register and company documents. And if I've seen it, and given that I only see cases that are going wrong, I suspect you've seen a similar increase as well. So if you get one of those requests, Holdsworth Village in Barton is the case you need to go to understand what is and isn't a legitimate request. I'm going to skip over the Bentham and Lindsay Court St Anne's case, because whilst it's very interesting, it's quite esoteric. It's about the interaction between right to manage companies and 1987 Act managers. The headline is that the 1980s, if you've got a 1987 Act manager in place, and then an RTM company is formed and tries to take over the block, the RTM trumps the management, so that the RTM company will end up taking control of the RTMable bit, and the manager can't oust the RTM company. Similarly, I'm not going to spend much time on Asset Hold and 63 Holmes Road. For the lawyers listening to this, because I know there are some looking at the delegate list, this is probably actually quite an important case for you, but for managing agents, it's a bit less so. It's about the gaming, frankly, that goes on in right to manage cases, with each party trying its darndest not to give the other information. So what happened in Asset Hold and Holmes Road is that the landlord had said, can you give us all this information, please? Because we'd like to see if you are indeed a properly formed right to manage company. And the RTM company said, no, you've got no right to this information. We're not going to give it to you because our experience is that you only ask for this information for the purpose of trying to identify defects, and we're not going to help you. In the FTT proceedings, the landlord said, look, we've asked for this information. We need to see it, because if we don't see it, we can't find out if they're an RTM company or not. And then belatedly, the RTM company gave all that information in the FTT proceedings, but they gave it at a time and in a manner. And the upper tribunal said, look, you can't do that. You're not allowed, either party, but particularly RTM companies, You're not allowed to refuse to give people information they ask for and then only give it at the last minute so as to prevent them from dealing with it. Once you get involved in litigation, the rules of the tribunal mean that everybody has got a duty to try and help the tribunal to resolve the case, which means resolving it quickly, cheaply, and with the minimum amount of formality. And if you start gaming when you give the information, you aren't complying with that duty. So I say for the lawyers involved, it's worth having quite a look. It's worth having a read of. It's quite interesting on tribunal procedure generally. Eastern Pyramid and Spire House. Again, I'll take relatively briefly because although it's a Court of Appeal case, it's a fairly esoteric one. It's about withdrawal of RTM claim notices. So as you know, if an RTM company can withdraw a claim notice at any stage, and aside from the liability for costs, nothing actually happens to you if you withdraw an RTM claim notice. You can give a new claim notice immediately afterwards if you want to. But the Act does say that to withdraw a claim notice, you've got to give it to the landlord and to the tenants. And it also says you can only have one claim notice at any time. So what happened in this case is that the RTM company served their claim notice. The landlord serves a counter notice in which he says, look, you've got this bit, and this bit wrong in the claim notice. The RTM company agree and they withdraw the notice and immediately serve a new claim notice that fixes those problems on the landlord. But the withdrawal isn't notified to the tenants until a couple of days afterwards. And so the landlord says the second claim notice is defective because he says you can only, you withdraw a claim notice by giving notice to the landlord and to the tenants. You have to give that notice at the same time, he says, and it isn't effective until both parties, landlords and tenants, have seen the withdrawal. Because you gave the second claim notice before you'd given the withdrawal notice to the tenants, that meant you hadn't withdrawn the first notice. And because you can only have one notice at any time, that means your second notice is invalid. And the Court of Appeal just say, no, that's nonsense. The critical bit with a withdrawal, says the Court of Appeal, is that the landlord knows about it because he's the only person that gets to serve a counter notice. He's the person whose rights are being affected. He can't say that because the tenants got the notice to withdraw late, the claim is somehow defective because it's nothing to do with him. How does the fact that someone else got it late cause him any prejudice whatsoever? Now, on the one hand, it's quite a narrow esoteric point because withdrawal of claim notices doesn't actually happen that often. What I think is more interesting about the Spire House case is that it's the latest in a fairly long line of RTM cases now, starting with the Ealing Court case, where the Court of Appeal have just said they've been very, very skeptical about technical notice-based arguments trying to invalidate the right to manage. The Court of Appeal have a very, very practical approach to this. And if it doesn't actually affect the landlord and harm him some way, they're upholding claims or acts of RTM companies, even where on the face of it, they haven't done what the act is actually specified. I understand why they do that, because as someone who acts mostly for landlords and who takes lots of very technical points, I mean, they are very unattractive. Turning up and arguing that an RTM should be invalidated because someone's put the comma in the wrong place. It's a very meretricious technical kind of lawyering that just isn't really finding favor with the higher courts these days. The only concern I have about too liberal an approach is I have two concerns, I suppose. The first is a bit more principled. But Parliament doesn't pass laws because it's bored and got nothing else to do. Parliament passes laws and sets procedures because that's what they want you to follow. And I do struggle with the idea that courts should just save you from being unable to do what Parliament says you should do. Parliament is supreme and sovereign, and if Parliament says that everyone has to stand on their head on a Tuesday, then I'm afraid you all have to stand on your head on a Tuesday. it's not really for you to question whether Parliament did it sensibly or not. That's not how law works. But secondly, all it does is it shifts the argument. So it shifts the argument from being, has there been compliance or not, to, well, what's the consequence of the non-compliance? It doesn't actually stop the argument being run. It's just that you focus on a different aspect of the argument. And so I'm not, for my part, sure that it saves very much time or money. But as I say, there we are. The trend is now firmly established. The Court of Appeal now in a number of cases are effectively saying this is a very practical scheme of legislation. If there's no practical problem caused, then we don't really think we should go around invalidating it. The oldest case on these notes, and one that is quite important, is the Duval case and Randolph Crescent. Oh, sorry, hang on. I've seen all these questions coming in. Excellent. None of those questions in the chat box were actually questions for me to deal with, so that's fine, so I can stop there. The Duval and the Randolph Crescent case. I've done webinars for News on the Block and other people about this. This is a hell of an important case. The critical thing to take out of this is you need to know in your leases when you've got absolute covenants prohibiting leaseholders from doing things, and whether the leases work on the basis of other people being able to enforce those. So let's just pause there for a minute and unpick Duval. And for those of you who've heard a Duval talk 4 or 5 times in the last year, I make no apologies because this is quite an important case. Leases generally say that leaseholders aren't allowed to do X. So, sublet, cut the walls, whatever it's going to be. But sometimes they say, without the permission of the landlord, consent not to be unreasonably withheld. And sometimes they just say you can't do X. This is about those cases where they say you can't do X. Before the Duval case, there was a pretty respectable argument that landlords who had those leases where it said you can't do X, if the tenant wanted to do X, they could say to him, well, look, I'm prepared to give you permission. Whether we do it as a variation of the lease or a license or some side agreement, doesn't really matter. I'm prepared to give you permission. But basically, you and I are striking a side deal. It's a commercial bargain. And so I can charge you a premium for it. So if what you want is permission to sublet and the lease completely prohibits it, I can tell you now my fee for striking that new bargain with you will be 10 grand a year, something like that. And there was a view that you could do that. The Duval case is about that kind of situation, and it rather changes the position. So in the Duval case, there was an absolute covenant saying that the leaseholder mustn't cut into the walls or the ceiling of the flat. And the tenant wants to cut into the walls and ceilings of the flat. The landlord is minded to go ahead with that, is minded to say fine, because it doesn't look like it will affect the building in any way, shape or form, so the landlord appears to be relaxed about it. But the other leaseholders in the building aren't, because the other leaseholders, particularly those on the same floor, I think from memory, the actual tenant who was next door, was not relaxed about it, because she said, look, I don't want to have to put up with the building noise and the dust, etc. And she said, I can't enforce the lease between another leaseholder and the landlord because I'm not a party to that lease. You can't go around enforcing contracts you're not a party to. But in my lease, landlord, it says that if I ask you to, you will enforce the covenants in everybody else's leases. I'm asking you to enforce the covenant prohibiting alterations. And if you grant permission, it will be impossible for you to enforce that covenant because you will have given a permission. And if it's impossible for you to enforce it, you will be in breach of your obligation to me, because as against me, you have to enforce those covenants if I ask you to. Therefore, you can't give permission. And it goes all the way up to the Supreme Court, and the Supreme Court say that is right. Absolute covenants prohibiting something aren't just about the relationship between that landlord and that tenant. They are normally covenants that are designed to protect the building and all the other leaseholders. So if you've agreed in a lease not to do something, and you've agreed that the other tenants can ask the landlord to enforce that thing, or to enforce that prohibition, then you can't, as a landlord, give permission to do that thing, because that would mean that you were in breach of your obligation to all the other leaseholders. Now, that's a really, really big deal as a case, because, as I say, frankly, lots and lots of landlords, I would probably go so far as to say the majority, would have been quite happy with the idea that you can give permission for things that are banned, and it's an additional income stream. And the answer is, you probably can't, actually. Depends on the wording of the lease, always depends on the wording of the lease. I've gone 22 minutes without having to say read your lease, but anyway, it always depends upon the wording of the lease. But it looks a lot more difficult than you might have thought it was at one stage. I'm 20 minutes so far. I'm not going to do anything on Holland Park and Hicks, because although it's quite interesting, I want to do other cases instead. I do want to flag up Bedford and Paragon Housing Association Limited, because this is quite an important one. So this is all about forfeiture, and we're in the second of my 3 parts of the talk now. As you know, if you want to forfeit a residential lease for a non-money breach, then you've got to comply with section 168 of the Common Holding Leaseholder Form Act 2002. And 168 says that you've got to prove that they're in breach in the tribunal or in the court, or in an arbitral tribunal, or they've got to have admitted it. And until one of those things has happened, you can't forfeit. For money breaches, it's the same, but it's section 81 of the Housing Act 1996. So in this case, you've got a lease of a whole house, and the lease prohibits subletting, and the tenant is subletting. The landlord goes for a section 168 determination, because they say, look, there is the clause. It says, thou shalt not sublet. You are subletting. We want to forfeit your lease. Therefore, we need to prove you are in breach. Please, tribunal, determine that you are in breach. The tenant says, you can't do that, tribunal, because although I am subletting, the landlord has known that for a long time, because I told him, and he did actually. It's quite an amusing little case on it. He did tell the landlord he was going to sublet, because at one stage there was an agreement that he could sublet for a short period of time, because he was going off to America to try and become an American, and then to qualify to play rugby for their international rugby team. So the landlord clearly does know there's subletting going on, and the tenant says, so because you know there was subletting going on, and because you know that I've been doing it for longer than we agreed, and you've been making service charge and rent demands of me, that amounts to waiver of the right to forfeit. And because you've waived the right to forfeit, there's simply no point to these proceedings, because you're never going to be able to forfeit my lease. So even if I'm in breach of covenant, you can't do anything about it by way of forfeiture. So these proceedings are an abuse. And the upper tribunal says, but that's not right. Firstly, although you keep asserting, Mr. Tenant, that it's been waived, I'm not entirely clear it has been waived, and certainly there's been no finding of that effect by the tribunal. So I'm not sure that evidentially you get off the ground. But even if you were right, and this is the important bit, even if you were right and it had been waived, that still doesn't mean it's an abuse, because forfeiture isn't the only thing you could do once you proved the tenant was in breach of covenant. You could go and get an injunction, for example. You could decide as a landlord, I don't want to forfeit your lease, but having proved you are in breach, I just want an injunction to stop you doing it again. Or you might want you might want to bring damages claims. If the breach has caused you loss, you might want damages. So the section 168 determination that there's been a breach, whilst it's a prerequisite for forfeiture, forfeiture isn't the only remedy. And that being so, it's not an abuse to bring a 168 claim, even if ultimately you may never get forfeiture. And I think that's quite important, because the reality is, frankly, the majority, I would put it as far as the vast majority of forfeiture claims end up failing on waiver, because waiver is just really easy to do and it's really common. And this shuts down the argument that you can't take that point in the sorry, it shuts down how the FTC deals with that. The FTC just shouldn't be getting into questions of waiver of breach. There's then a relatively, at least factually, quite amusing case, but quite important case as well about how you prove a forfeiture and prove a 168 case. Marchitelli and Westgate Terrace. Marchitelli is the leaseholder. It's a term of her lease that she mustn't permit or suffer any illegal or immoral act or anything that would be a nuisance within her flat. She sublets the flat to X, and X then uses it as a brothel. The evidence about the brothel is quite amusing. If you've got nothing else to do of an afternoon, have a read of this case, because people seem to deny this is a brothel, and if it's not a brothel, then I have no idea what on earth else was going on in that property, and I'm not entirely sure that there's any reasonable reading of that evidence suggests that this is a brothel. Anyway, the freeholder says, look, running a brothel is a breach of lease. It's illegal, and it's immoral, and it's definitely a nuisance. So I want a determination that you're in breach because I want to go for forfeiture. And in the FTT, everyone focuses on, is it a brothel or not? So we get all this evidence about how many people visit and the state of undress of the various occupiers. And I think from memory, some of the prostitutes are transgender, which then seems to confuse the FTT no end at all, trying to understand what's going on here. I can only imagine the FTT chair and members doing this case were given quite an education into contemporary sexual practices in England. But ultimately, they find it's a brothel and they find that's a breach. She appeals to the upper tribunal, and the upper tribunal says, but look at the lease. You've got to permit or suffer the illegal or immoral act, or permit or suffer the thing that is the nuisance. So whether or not it's a brothel isn't really the issue. The question is, did the tenant permit or suffer that thing? And she had led evidence, the tenant, that she had been incredibly unwell throughout this period. I think from memory, she'd been hospitalized for large chunks of it. And she'd asked her managing agent to try and evict her subtenant because she didn't want a brothel being run there. Well, said the tribunal, if that's true, that's pretty obviously her not permitting or suffering the act. She's trying to stop the act. And if she's trying to stop it, she cannot be permitting or suffering the use of the property as a brothel. And the tribunal just hadn't grappled with that. It had got so fixated on the evidence about the brothel that it had stopped looking at the words of the lease. And it hadn't asked itself, was she permitting or suffering it? And so they sent it back for retrial on that question. Was she permitting or suffering? Or alternatively, as she said, was she trying to stop the nuisance? So it comes back to the same a point we made a minute ago. It's about the importance of the terms of the lease. Because that very long and from the looks of it, quite expensive trial about was there or was there not a brothel wasn't really the question. The question was the tenant or the leaseholder responsible for that? Was she permitting or suffering it? People just ask themselves the wrong question. Then I'd also flag up Triple Rose and Beatty. It's another of the long-running series of cases we're getting now about Airbnb-style platforms, and whether renting out a flat on Airbnb is a breach of a term of a lease, where the lease requires you to only use the property as a private dwelling or not to run a business from the property or something like that. And again, to repeat myself from the last case, it's about the importance of looking at the terms of the lease in question. So this lease said that you were prevented, well, it had two clauses to it. The first is you had to use the property as a private dwelling house for one family. And the second part said you mustn't carry out a business, quote, upon the property. So was running Airbnb style flat accommodation from the flat a breach of either of those two covenants? It's a breach of the first covenant, because letting people live in a property for very short-term accommodation, often just a long weekend, is not using the property as a private dwelling house for one family. It's using the property for occupation, not as a dwelling house at all, but as a hotel, effectively, by lots of different people. So it's a breach of that bit of the covenant. But perhaps surprisingly, it wasn't a breach of the covenant about running a business, because the covenant said you mustn't carry out a business upon the property. And the upper tribunal said, well, you're not carrying out the business upon the property. The carrying out of the business, the taking of the bookings, the receipt of money, etc., none of that was carried out upon the property. It was carried out elsewhere, wherever you were sitting with your computer when you took the booking, etc., etc. So it wasn't a breach of that covenant. I have to say, I'm a little bit surprised about that. I would have thought the business is the letting of the land, and the occupation of the land is the carrying out of that business upon the property. But the upper tribunal, that was an argument that was right. The upper tribunal said no. Upon means something important here. The upon is looking at the location from which the business is run, and the business is run not from the flat, but from elsewhere. So again, it's the importance of knowing what your lease says, because I know as well as you do that Airbnb cases are as common as they come, and the wording of the leases is critical. It suggests something I've broadly thought for a while, that the better way of dealing with Airbnb cases is the private letting properties, or covenants that say you mustn't do something that would invalidate the insurance, because generally building residential insurance policies don't provide for Airbnb, and it's a ground for avoiding the policy. So rather than going down the business route, because for various reasons I don't need to go into, some of the cases about running a business are really quite difficult. You've got loads of old cases from pre-World War One, all about whether taking in a lodger is running a business and such like, and it just ends up getting very, very messy, the business cases. I think the better way to go down is private dwelling house or insurance covenants. Finally, turning to service charge cases. I want to deal with this mayor and commonality of City of London against the leaseholders of Great Arthur House, mainly because so many people are really excited by this, and I don't really understand why. It's all about whether you can charge a service charge for fixing some inherent defects at a building. So what had happened is that this particular block of flats in the City of London, it's built in such a way that you inevitably get water ingress. I don't quite understand it myself, but it's something to do with the various, how the bits of concrete that put it together were joined up, and it's inevitable that water's going to get in. So are you allowed to charge the leaseholders for that? And the Court of Appeal and the Upper Tribunal before that said no. And they do that with a very, very close analysis of the wording of the lease in each case. But these leases are really weird because they're old style right to buy leases. So they're right to buy leases granted between 1980 and 1986, when the right to buy changed. That's not quite true. They're actually, some of them are actually granted after 1986, but for reasons I don't understand, the City of London continued to use pre-1986 right to buy lease wording. I'm sure they had a reason for it. I just don't know what it is. But basically, this is about, you will only find this form of wording in right to buy leases granted between 1980 and 1986. And this particular, the right to buy between 1980 and 1986 had this incredibly strange way of dealing with service charges, which effectively excluded a huge range of things that you and I would think of as normally being service chargeable costs. It just banned them from ever going through the service charge. And after 6 years of working it that way, everyone realized if you carried on doing this, local authorities were going to have massive financial shortfalls for hundreds of years to come. So they changed how service charges work in 1986 for right to buy leases, which is why I don't think this case is very interesting, because I haven't seen many of these weird leases granted since 1986. But anyway, what it concludes is that this particular weird form of wording that only applied to right to buy leases for 6 years doesn't let you charge for fixing inherent defects in a property. The reason people have got really excited about this is various cladding groups have been touting that the idea that this is a general answer to cladding cases, and it shows you're not allowed to charge a service charge to remedy an inherent defect, and that therefore that charging to remedy cladding isn't permitted. And that's just not what this case says at all. This case is about a really, really weird form of lease that would never have been granted by a rational person, and was only granted because the right to buy legislation made you grant it in that form for a period of time. I do not think this is a case of general importance. It's quite important for the City of London, but I don't think this is a case of any wider importance. And I don't think it's an answer to the cladding cases. So I'm not going to spend any more time on that one. Coming on down the slides, CH Residence Company in Hislop. This is a lovely one to have. This is that situation which I'm sure that none of you ever have. So forgive me for suggesting this. It's a leaseholder who just denies she ever gets any correspondence. She denies she ever gets these bills, and therefore that's why she hadn't paid them. And there's a dispute in the FTT about whether or not she did get them. And the FTT said that the landlord couldn't prove she'd received them, and so there was never a demand to pay. The upper tribunal is quite rude about the FTT in this case, I have to say. Firstly, the FTT had asked itself whether it could be said, quote, with any certainty that they'd received the demands. And the upper tribunal says, what? With any certainty? That's not a legal test for receipt of documentation. There are two kinds of legal test. Balance of probabilities, i.e. is it 50.01% more likely, or beyond reasonable doubt, the criminal standard. With any certainty isn't a test isn't a test known to law. And it's a civil case, this one, so the test should have been balanced probabilities. So is there a 50.000001% chance that she received this document? If so, landlord wins. If it's only 49.99999 recurring, then leaseholder wins. So let's have a look at the evidence. Right, there was a photograph from the managing agent of him pushing the demands through the letterbox of the flat. Okay, says the upper tribunal, well, let's consider that evidence. There are two scenarios, aren't there? Either it's true and he put it through the letterbox as per his photograph, or he took the photograph for the purpose of enabling him to run a fraudulent conspiracy at a later date. That's not very likely, is it? It's much more likely that he took a photograph of him pushing it through the letterbox because he wanted to prove it went through the letterbox. So you should have found that this was at least a 50.00001% chance that the notices have been, the demands have been sent, and therefore they should have been paid because there was no challenge to the actual amount. It just makes me laugh because it just shows something I've been saying now for, I don't know, a decade or so. Service of notices, service of documents isn't a legal question, it's a factual question. And for the people, I've think of it for a long time, for the people that deny they're getting everything, a photograph, you putting it through their box is pretty clear evidence they did get it. I just think this is a good example of that. For the people that deny it, just produce absolutely incontrovertible evidence. One very important case, very, very important case, called Aviva and Williams, is all about the apportionment of service charges. Now, as you know, service charges can be apportioned in a variety of different ways. This is about a situation where the apportionment is discretionary, so it's not fixed by a percentage or by floor area or anything like that. It's fair and reasonable or something like that. And the ascertainment of what is fair and reasonable is put in the hands of the landlord or the landlord's surveyor or someone like that. It also applies to situations where you've got a power to change the apportionment. So where the initial lease says that the service charges are 0.4% unless varied in accordance with Schedule 6, and Schedule 6 says the landlord can vary it in a way that's fair and reasonable, etc., etc. It's about the control of that discretionary power. So this is the second time this question has gone back to the Court of Appeal about how do you regulate that discretionary power? And what they say is this: where you've got a discretionary power on the allocation of service charges, the effect of the service charge legislation is that you have to get your pencil out and cross out the bits that give the discretionary power to the landlord or the landlord surveyor. If there's a dispute about what's fair and reasonable, then the tribunal has to decide that dispute. And the tribunal decides for itself what's fair and reasonable. It doesn't just review the decision of the landlord or his surveyor. So it doesn't just say that is a decision within the range of reasonable decisions. It has to decide for itself what is the fair and reasonable apportionment. And it can do that if the landlord applies for a determination or if the tenants apply for a determination. It's really, really important because it makes challenges on discretionary apportionment much, much more common and much easier to run. It doesn't necessarily make them easier to win because the tenant is still going to have some kind of evidence to show why X proportion should be chosen as the Y proportion. But it means that you can't just say, as landlords will want to do, well, look, my surveyor is an RICS qualified member. He sent the assessment. That's the end of it. That's not the end of it. If they don't agree, the surveyor or the landlord's reapportionment, then the tribunal has to decide for itself whether or not the allocation is fair and reasonable. I want to touch very briefly on the Powell and Alexandrov one. Just for those cases where you've got old leases that say things have to be certified by a chartered accountant. It's a discussion about what certification means in this context. I won't spend much more time on it than that beyond simply saying if you want it, then if you've got one of those leases, that's the most recent decision on this. So have a look at Powell and Alexandrov for what certification means. Kuro and Pimler isn't very interesting, and I say that as someone who was in it, so we're not going to talk about it. Lambeth and Gesnowitz is also not very interesting, so we're not going to do that. Which one's Lascar? No, I'm not going to do Lascar. It's not very interesting either. I'll do West India Key because that is quite interesting and important. I'll do Gell, and that'll probably wind us up. Just check. Yeah, that will wind us up. Oh, West India Key. I've been involved in this case for longer than my son has been alive, and he's currently 6. This is the most long-running case I've got on my desk at the moment. It's a horrible case. It is a building. It's about the apportionment of utility costs, and it's ended up generating huge amounts of law on all kinds of things. It's about utility costs. This is a really, really complicated building. You've got a hotel making up the first 13 floors of the building. You've then got some service departments, and then you've got the residential flats. The utilities relate to the building as a whole. So the water, the gas, the electrics, they come in off the street and they're measured at the front door, effectively, of the whole building by bulk meters that belong to the utility company. You've then got sub-meters that try and work out how much of, say, the electricity goes to the commercial, how much goes to Resi. And then within Resi, you've got meters that try to work out how much has gone to a common part or plant and how much has gone to each individual flat. And what's supposed to happen is that there are supposed to be hundreds of meters throughout the building, all of which generate an electrical signal that you can read remotely. And once you know what the input figure is, based on the figures at all the other meters, you can allocate the costs thereafter. This is apparently a form of metering design that was very popular for about 5 years and then fell out of fashion because people realize that it doesn't work. It doesn't work because if one of the meters breaks, it destroys the whole calculation process. And so you end up having to do guesstimates. And in a building with hundreds of meters, it's inevitable that one breaks from time to time. These meters have been going wrong for a long time, and they're slowly deteriorating. Because it's so complicated, the landlord, who's my client, doesn't actually read the meters himself. He gets a specialist company to come in, read the meters, and work out what the allocations are. He charges the cost of that specialist company to the leaseholders. There are two different clauses he could have used in the lease to charge the leaseholders. The first clause says that they've all got to pay for the electricity and the gas and the water, etc. And the second clause says that he's allowed to charge them for professional services relating to the development. I'm simplifying enormously, but those are the two clauses. He charges them under the first clause. He says the cost of reading the meter and working out the apportionment is itself, or should be treated as, a cost of the actual service. So he charges it as a surcharge on the actual utility cost. That's challenged in the tribunal. He wins in the FTT. The FTT said, yeah, that's fine. It goes to the upper tribunal in 2016 and he loses. The upper tribunal says, no, it had to be demanded under the other bit of the lease. It's a professional service. It's not the cost of the utility. And they send the question back to the FTT to work out how much is due. Now, the problem is that it's only ever been demanded as part of the electricity. It hasn't been demanded as a separate charge. So can you now just redemand it? And this is where 20B comes in. 20B, as you know, is the 18-month rule that requires you to make a demand within 18 months of incurring the cost. And it's been held in the High Court that the demand has to be a contractually valid demand. And they've never made a contractually valid demand. They thought it was contractually valid by demanding it as part of the electricity, and the FTT agreed it was contractually valid, but then the upper tribunal said it wasn't. And by the time the upper tribunal decision comes out, more than 18 months has passed since the cost was incurred. So now you can't go back and make a contractually valid demand. The landlord says, look, all these cases that say it's got to be a contractually valid demand, they are wrong. All that matters is you made a demand, and I did make a demand, albeit under the wrong bit of the contract. 20B is not about creating a trip route for landlords. It's about making sure leaseholders know what they're going to get billed. And they did know what they were going to get billed, albeit I charged them under the wrong heading. The upper tribunal, the FTT says that's very interesting, but there's a High Court decision that says it's got to be contractually valid. It isn't contractually valid, so that's the end. The upper tribunal says, I have a lot of sympathy for that argument. I personally think that the law probably did go wrong by saying it's got to be contractually valid. But the High Court and the upper tribunal are at the same level, and it would not be a good idea for me to say the High Court is wrong, because that will introduce chaos into the law. So I'm going to dismiss your argument, and I'm going to give you permission to appeal, to go to the Court of Appeal, and the Court of Appeal can decide if you're right or wrong. And the Court of Appeal have decided that I am wrong. 20B does require a contractually valid demand within 18 months. They say it's not about information and making sure the tenants know what they're going to get. They say this is akin to a limitation period, and the limitation period is designed to be hard-edged and to have unfair consequences if people miss it. It's about certainty, not information. So it means that your demands must be contractually valid, because if they are contractually invalid and 18 months and 1 day passes, you are dead and can never have that money, unless you've served the 20B2 notice. And so I think the takeaway from West India Key is that you should be serving 20B2 notices at every single conceivable opportunity, even if you don't think you need to, because if it later turns out that your demand is contractually invalid, then you can't go back and save yourself later. And this is why I think West India Key is quite a good example of how this can be unfair, because our demand wasn't challenged for many years, and when it was challenged, the FTT said it was fine. It was only when that was overturned on appeal that we realised we had a problem, by which time it was too late. The other thing that this deals with, this case, is all about legal costs. And again, for the lawyers involved here, this is a really, really important one. If you're going to try and claim your legal costs under a forfeiture costs clause, so the 69 Marina type arguments, you do need to prove and evidence an intention to forfeit. So in your letter before action and in your pleadings, you need to say, this is all in contemplation of forfeiture. We'd never done that. We said there was no point, because until you got the determination, you couldn't forfeit anyway. And the Court of Appeal say, no, that's wrong. You do have to plead and prove an intent to forfeit if you want to rely upon a contractual costs clause. We have asked the Supreme Court for permission to appeal. We haven't got a decision back on that yet. I don't know what they're going to do with it. But at the moment, this is the law, and it's pretty bad news for landlords, I'm afraid. Finally, in the last couple of minutes, then we'll turn to some questions. Quite an important case to end on, again, for everyone, but particularly for the lawyers, Gell and 32 John Road. It's all about, what does a leaseholder actually have to do to challenge the service charge? Procedurally, this case is a mess. Things just go a bit weird in the county court. And I'm not going to trouble you with the procedural side of it, because although it's quite important for the lawyers, it's just a bit of a mess and will confuse things. The important thing was the Court of Appeal looked at, well, what do you actually have to do in order to establish that you are challenging a service charge as a leaseholder? And they say, you've got to do, you can't just ask questions, leaseholder. To challenge a service charge as not being reasonable, you've actually got to set out what items you think are unreasonable and why. You don't necessarily have to have all the evidence to that effect, but it's not saying, I want you to prove it's reasonable is not a defense. You have to raise some argument that would suggest to a judge or a tribunal that there's something here that needs to be examined. You can't run a defense that's basically just an auditing argument, saying prove every demand was incurred, etc., etc. You've actually got to run something positive. And I think that's quite important, because we all know that lots and lots and lots and lots of leaseholders simply say prove it's reasonable. And that's not right, says the Court of Appeal. Reasonableness is not a proof for a landlord to jump through, not a hoop for landlords to jump through. It's a protection for a tenant who wants to claim it. So you've got to do something to suggest, or to show that there is some argument that there is an unreasonable charge that needs the tribunal or the court to intervene. That's all my notes I've rattled through there. You should hopefully get them all in writing shortly. I'm just looking at the yeah, so the questions in the chat box were all about the notes. So hopefully Vicky sent them all out to you. If not, this has been recorded, so later on, for your own delectation, you can sit and watch it again, holding the notes in one hand and looking at the screen.
Yeah, I sent them at the beginning, Justin, so everyone should have had them throughout on their email to read through with you.
Fine. Well, I mean, if not, you've got them all later. I mean, this is why I write very long notes, so that you can read them later in your own free time. Right, so Q&A then. Let's see if anything in the Q&A. Whilst challenging subject information, can the letter be surrendered and regranted? Yes. So you need to think about the different kinds of service charge apportionments. It's not that you can challenge any apportionment. If the lease says that the tenant pays 1/10, let's say, and it just, it says in terms, you will pay 1/10 or 0.10%, or however you want to express it, with no power to change, then you can't challenge that apportionment in the tribunal, because that's been determined conclusively by the lease. The way it works is that's treated as an agreement, an admission that the X percentage is due, because you all agreed to that in the terms of the lease. If the lease gives you a discretionary apportionment, then the exercise of the discretion can be challenged by either party in the tribunal, and the tribunal will decide for itself how that discretion should be exercised. If you wanted to surrender and regrant a lease, a surrender and regrant is a consensual arrangement. The parties agree, generally in exchange for money from tenant to the landlord, that the old lease will be ripped up and a new lease will be agreed, and you can agree whatever terms you want. It's got nothing to do with the tribunal, but the terms you put in it might be relevant later on. So if you do a surrender and a regrant and you agree in there the percentage will be 1/10 and you write that in terms, you can't ever challenge that apportionment in the tribunal. If you agree it will be such reasonable sum as the landlord or his surveyor may consider, then you need to be aware that the tribunal will have the final say in the event of a dispute about what is reasonable in those circumstances. But the surrender itself has nothing to do with the tribunal. So I will answer that one there. Any more for any more? The thing is, I can't see any of you is, for all I know, you've all just given up and gone home and just left your screens running. Brett, at least, has been kind enough to say that he's left already. Any more for any more? We've got a couple of minutes. I'm happy to hang around for another 2-3 minutes.
Oh, I was about to say that's a very good sign when there's not a lot of questions because you've covered everything, but you've just got one more pop up.
Right. So it's a question about backdating charges. So service charges have to be demanded of the leaseholder within 18 months of being incurred by the landlord. And they are incurred when the landlord gets the bill or when he pays it. It shouldn't really matter. There could conceivably be a difference, but it shouldn't really matter for most purposes. So if the landlord got a bill on the 1st of January 2020, and he doesn't bill you for that, he doesn't bill you your share until the 1st of January 2022, then on the face of it, his demand is invalid because more than 18 months have passed since he incurred that cost. 24 months have passed. And at 18 months and 1 day, you're dead. So if someone went back and tried to redemand, I don't know, say 5 years worth of service charges in one go, my very, very strong suspicion, unless there was something quite weird going on in the background, is that all of those demands are going to be invalid. You can only go, only got 18 months. That's the point of the West India Key case. You've got 18 months to make a demand. And if the 18 months are passed, at 18 months and 1 second, you can't have the money anymore as a landlord. He hasn't got to have collected it from you. He's only got to have demanded it from you within those 18 months. So in principle, going back many, many years is not something that should really happen under residential leases. I don't want to say it could never happen because there are always slightly weird scenarios that might arise, but in the vast majority of cases, it won't work. If charges add up to more than 100%, can it cause problems? Yes, but if charges add up to more than 100%, there are, I think there's a couple of answers to it. One is that depending on the wording of the leases, you might actually have to do a prorated reduction. So if the lease says, for example, that they only pay towards a cost, then the cost can only be 100% of the cost, because at 110%, it isn't a cost. The additional 10% is now a profit. Cost relates to a cost means something that has been expended. So you might have to do a pro rata reduction just to comply with the terms of your lease. But in practice, if you've got more than 100%, an informal pro rata reduction works for a bit, but you are going to have to bring it down to 100. The best way of doing it, I would have thought, in any kind of decent sized block, would be to go and get the tribunal to do a variation under section 35 or 37 of the 87 Act. And if you've got a block of 3 flats, I'm sure you should be able to agree it. But a block of 50, you aren't going to get it agreed. So the answer is go to the tribunal and have them do a variation under the 87 Act. I'm not going to answer the very last question because we're now getting into someone's individual personal circumstances. And I'm not going to advise you on your individual case because I need to see your papers and I'd want to be paid. So beyond simply there being very broad principles, if you go back, you shouldn't see service charge demands that are more than 18 months old. It's not impossible. There are circumstances when you can go back further than 18 months, but as a starting point, if it's older than 18 months, the landlord's got a problem. Any more for any more there? I think that's it, isn't it?
Yes, I think so. I can't see no more coming in. Yeah, I'm happy to finish up there if you're ready, Justin.
I am. And I'm going to have a coffee. And
yeah, we've got a few comments in the chat to say thank you. That's been very useful. So thank you very much, Justin. Your sessions are always really informative and always really popular.
That's all right. It's fun to do them.
Good. I'm glad.
It's just nice. It's nice to see the names of friends popping up in the chat.
It is. Yeah, it's good to see some familiar people, isn't it?
It is. It's also because, of course, I haven't actually seen another human being other than one I'm related to for almost 2 years now. So it's nice to know. It's nice to know that some of these people are still alive.
It is. Yeah. Maybe we should do another session where it's a bit more interactive and you can see people. That might be nice.
Maybe we should hire. I mean, like, because I mean, I know that now we've got the money for this. Why isn't the next leasehold conference? Why don't we do it on an island somewhere? Nice warm up.
That would be lovely.
Everyone's got to have a PCR test before they're allowed in. I think
like a party island for leasehold.
Well, just to see people in a nice environment. That'd be the plan. So yeah, right, absolutely. Guys, we better leave it here because everyone's got work to go and do. So thank you very much for your time.
Okay, thank you so much for your time today, Justin. Again,
no worries.
Thank you to everyone else for joining us. Right. If you want to join us for any more sessions, then please take a look at the schedule on the website. Otherwise, thank you. Enjoy the rest of your day. Bye.